Question 156. Someone who is an innocent purchaser of a negotiable note with no knowledge of any defect is A. Correct answer is B. Holder in due course. Holder in due course, HDC, is a legal term that refers to someone who acquires a negotiable instrument, like a promissory note, in good faith, for value, and without notice of any defects or claims to it. This status gives the holder certain protections and rights, such as the ability to enforce the note even if there are defenses that could be raised against the original payee. Question 157. Recording is not required for A. Homestead declaration, B. Notice of default, C. Notice of completion, D. Grant deed. Correct answer is D. Grant deed. A grant deed is legally valid between the buyer and seller even if it's not officially recorded. Recording primarily serves to publicly document the ownership transfer, protecting the buyer from potential future claims. Other documents like notices of default and completion, and often homestead declarations, typically require recording for legal effect. Question 158. A contractor built an outdoor stairway for a home being renovated. The owner later refused to pay the contractor for their work. The mechanic's lien filed by the contractor reverts back to the date A. Renovation was finished, B. Renovation began, C. Contractor's work was finished, D. Contractor's work began. Correct answer is B. Renovation began. Mechanic's liens, in many jurisdictions, relate back to the date that work commenced on the overall project, not just the specific work done by the individual contractor. This is to ensure that all contributors to the project have equal priority in claiming their due payment. In this case, the renovation of the home is the overall project. The contractor's work on the stairway is part of that larger renovation. Therefore, the lien's priority will be determined by when the renovation began. Question 159. Good faith deposits can be in the form of A. Money order, B. Cashier's check, C. Promissory note, D. All of the above. Correct answer is D. All of the above. A money order is a secure form of payment, making it acceptable as a good faith deposit. A cashier's check is also a secure form of payment, as it's drawn on the bank's own funds. In some cases, a promissory note, a written promise to pay, can be used as a good faith deposit, though this is less common than cash or checks. It is still a valid form of consideration. Therefore, all the listed options are acceptable forms of good faith deposits. Question 160. Information from a Chapter 7 bankruptcy are kept on credit records for blank. A. 5 years, B. 7 years, C. 10 years, D. Forever. Correct answer is C. 10 years. Chapter 7 bankruptcy is a legal process where a person's non-exempt assets are sold to pay off debts. This allows for the discharge of most, but not all, debts, offering a financial, fresh start. Eligibility is determined by income, and some debts, like student loans, are typically not eliminated. It serves to liquidate assets and discharge eligible debts. Chapter 7 bankruptcy filings remain on credit reports for 10 years from the date of filing. Question 161. Which of the following statements is true regarding straight notes, a kind of promissory note? A. Require interest payments only until a balloon payment on the balance is made at the end of the term. B. Require payments for a portion of the principal along with interest payments throughout the term of the note. C. Cannot be used as security for a mortgage. D. The lender of a straight note cannot assign it to someone else. Correct answer is A. Require interest payments only until a balloon payment on the balance is made at the end of the term. A straight note, also known as an interest-only loan, is a type of promissory note where the borrower only pays interest during the loan term. The entire principal balance is due in a lump sum, balloon payment, at the end of the loan term. While installment notes involve making payments on the principal amount as well as interest. Promissory notes are secured by a mortgage or deed of trust. Unless specifically prohibited in the language of the note, a promissory note is assignable by the lender. Question 162. Which of these legal actions follows the granting of a judgment? A. Lee pendens. B. Interpleader. C. Writ of execution. D. Unlawful detainer. Correct answer is C. Writ of execution. Lee pendens is a notice filed to inform the public that a lawsuit is pending that may affect the title to real property. It's filed during the lawsuit, not after a judgment. Interpleader is a legal action initiated when two or more parties claim an interest in the same property held by a third party. It's not a direct consequence of a judgment. Unlawful detainer is a legal action taken by a landlord to evict a tenant who is in unlawful possession of the property. It's a separate legal process, not a general consequence of any judgment. A court judgment is a formal decision by a court in a lawsuit. Writ of execution is a court order that authorizes a law enforcement officer, like a sheriff, to seize and sell the judgment debtor's property to satisfy the judgment. It's a direct action taken after a judgment has been granted to enforce it. Question 163. If a lender accepts a deed instead of foreclosure from a trustor, the lender will A. Assume liability for any junior liens. B. Obtain the property without any encumbrances, regardless of junior liens. Provide the trustor with a reinstatement period to pay off the default. D. Sue the trustor in civil court. Correct answer is A. Assume liability for any junior liens. Deed in lieu of foreclosure is a process where the borrower, trustor, voluntarily transfers the property to the lender, beneficiary, to avoid foreclosure. It's a way for the borrower to potentially avoid the negative impact of a foreclosure on their credit. When a lender accepts a deed in lieu, they take the property subject to any existing junior liens, second mortgages, home equity lines of credit, etc. Unlike a foreclosure sale, which can wipe out junior liens, a deed in lieu does not. Question 164. If an offer to buy a property is accepted by an owner who then, before the close of escrow, decides not to sell, then the buyer can A. Pursue a legal action against the owner for specific performance. B. File a criminal action for fraud against the owner. C. Acquire the property anyway under the doctrine of adverse possession. D. None of the above. Correct answer is A. Pursue a legal action against the owner for specific performance. Specific performance is a legal remedy where a court orders the breaching party, the seller in this case, to perform their contractual obligations. In real estate transactions, specific performance is often sought because each piece of real estate is considered unique. If the buyer can prove a valid contract exists, and that they are ready and able to complete the purchase, a court may order the seller to transfer the property. Question 165. A contract stating that a seller will pay a commission to a broker, if the broker finds a ready, willing, and able buyer and the broker promises to employ due diligence in procuring a buyer, is called A. Unilateral reward contract. B. Unilateral executed contract. C. Bilateral executory contract. D. Installment contract. Correct answer is C. Bilateral executory contract. Bilateral contract involves two promises. The seller promises to pay a commission, and the broker promises to use due diligence. Executory contract means that the contract is not yet fully performed. Both parties still have obligations to fulfill, the broker to find a buyer, and the seller to pay the commission if a buyer is found. while an executed contract is one that has been completed.